Matt Day here with Parsons, Graham, and Day, continuing to look at protective orders because there's actually a multitude of areas in which a protective order can impact your life. I was recently asked by a client whether or not they could list their children on the protective order. And so there's actually a couple different answers to this question. Starting off, generally, yes, if they fit within the allegations. That is to say, do the allegations somehow concern them? For instance, if they are children who were present during an act of domestic violence, the court may leave them on the protective order and you may list them on the protective order. If you are the victim of harassment or stalking and the children are not the other person's children but have been present during that conduct, you may be able to list them as additional petitioners or plaintiffs on your petition. So generally speaking, yes, you can list children on your protective order. If the children are the result of the relationship with the defendant, then the protective order, while they can be listed there, is only a very temporary thing, because in the state of Oklahoma, it is improper to use a protective order to permanently impact somebody's visitation or custody rights. So what that means is the court should be instructing you that once you find your protective order, well, let's assume that it's granted as an emergency. It's got you and the child or children listed as petitioners or protected persons on the petition. There should be an instruction from the court for you to go and seek emergency custody of that child or those children before the next court setting. That frequently happens in Tulsa County. They will issue an order telling you that you need to obtain emergency custody before the next setting. So, back to the original question. Can you list your children on your protective order? Yes. The court's going to look and see if they factually fit within the narrative that is being presented to it for purposes of the emergency. If they are the children of you and the respondent or the defendant, the perpetrating party, then the court typically is going to instruct you to use the appropriate method to deal with custody and visitation issues, which would be to file for an emergency custody action against the other party. All right? So, children can be listed. Sometimes, though, it is just a temporary listing of the children until a court with proper jurisdiction hears a family law case, like a custody case, such as a paternity case or a divorce, including minor children. If you find yourself in this situation, you need to hire yourself an attorney. Give us a call at 918-307-1529. You can also find out additional details at our website, www.pdtulsalaw.com. The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish an attorney-client relationship between Parsons, Graham, and Day and anyone watching this video.